Hello, I'm Constitutional Attorney Katherine Henry, and today is a continuation of our mini-series on 85 of the most common criminal law terms and their definitions. So to jump right back into it, corroborating evidence, additional evidence that tends to strengthen or confirm evidence already given. So if you have one really great star witness in a prosecution and they testify to a whole bunch of aspects, and then you have a bunch of corroborating witnesses that are each going to essentially support different elements or aspects of the original person's testimony because they each saw some different portion or piece of the crime, and they're going to testify just to the piece that they saw. They would be the supporting witnesses, but that's what that definition is. Criminal insanity, the lack of mental capacity such that a person may not be held legally responsible for what would otherwise be criminal acts. Cross-examination is the questioning of a witness by a party opposed to the party who produced him, to test the truth of the witness's testimony, to further develop it, or to otherwise expand on it. So again, the example would be if the prosecution in a criminal case, they have their witness. They start with, an eyewitness that supposedly saw the defendant fleeing the scene, and they have the initial line of questioning by the prosecutor of that witness. That's the direct examination. And then the defense attorney, if I'm serving as the defense attorney, then I step up and then I do my cross-examination of that prosecution witness. And so I'm going to try to poke holes in all the things that they're saying and show ways that they're lying and how they're not credible. And so that is my cross-examination. A consecutive or cumulative sentence, that is where sentences for two or more crimes run successively rather than concurrently. So concurrent means you're serving sentences for two different crimes at the same time. And consecutive or cumulative means they are tacked on one, then the other in succession. Direct evidence, proof of facts by witnesses who personally saw deeds or heard words spoken that constitute the facts to be proven, as distinguished from circumstantial evidence that we mentioned earlier. Direct examination, we've already alluded to it when we talked about cross-examination, but in direct examination in a criminal case, when you are the prosecutor and you have your witnesses, let's say a police officer, you are going to question that police officer during direct examination, and you must ask them open-ended questions to prove the truth of the matter that you have asserted. And then the defense counsel has the opportunity to cross-examine your witnesses, such as that police officer. And all those questions, they can be leading, they could be yes or no type questions. And that's the proper scope of cross-examination. Discovery are the procedures available to a party to a lawsuit to ascertain facts relating to the issue to be determined that are known to the other parties or witnesses to enable the party to prepare for trial. So in criminal cases, you depends on the jurisdiction. Sometimes in misdemeanor cases, some jurisdictions say that you don't have an automatic right to discovery, which is totally asinine because I don't care what you're charged with. Due process requires that the other side gives you the evidence so you have a proper and fair chance to prepare for trial and defend yourself and your rights. Dismissal, an order or judgment finally deciding a particular case in favor of the defendant by sending it out of court without even having a trial. And you can get a dismissal with prejudice or a dismissal without prejudice, which we'll talk about later on in these definitions. Double jeopardy, being placed more than once in danger of being convicted and sentenced for the same offense, and that is strictly prohibited by the U.S. and state constitutions. You cannot be charged and punished for the same crime more than once. Due process of law, the fundamental rules that guarantee fair play in the conduct of legal proceedings. For example, the right to an impartial jury and judge, the right to present evidence on one's own behalf, the right to confront one's accuser, the right to be represented by counsel, etc. Embezzlement is the wrongful taking of property or money by a person to whom it has been entrusted. So it's different from theft, because typically with theft, it's somebody is taking something that they didn't have a right to take in the first place. But with embezzlement, it's where you have someone who's typically in a fiduciary role where they've properly had the custody of the funds. Somebody gave them their money or their assets to manage or to hold for them, but then they have misused that and converted it or taken it and used it for themselves, etc. Entrapment, inducement of a person by officers or agents of the government to commit a crime that he or she would not otherwise have committed, just in order to prosecute that person for something. That is entrapment. Ex parte, by, for, or on the request of one party only, without notice to any other party. A big no-no, especially in criminal cases. There should be no ex parte communications with the court by either side. Ex post facto, after the fact. An ex post facto law is one enacted after the commission of an act, which retroactively changes the legal consequences of that act. So if I go out right now and I do cartwheels out at the sidewalk at my road, it's totally legal, it's totally fine. And let's say next week, the City of Ormond Beach Commission decides that they're going to implement an ordinance that says it is illegal, it is a criminal offense to do cartwheels on the sidewalk in front of your house in the City of Ormond Beach. And we're going to retroactively apply this so that all cartwheels done on sidewalks throughout any time in 2026 are included in this, and you can be criminally prosecuted. That would be an ex post facto law, because they're trying to punish me for doing something that was not inherently wrong, and they've just tried to make it wrong by their regulation after I've already done it, and then apply that regulation to me. Totally unconstitutional. Exhibit is a paper or article submitted in court or produced during a trial or hearing and formally made part of the record. So it's not just during a trial or hearing, though. That's the important part you need to consider, that an exhibit can also be, I've introduced a ton of exhibits that are attached to motions or briefs or other documents that are other pleadings that are filed with the court. I have attached that evidence as exhibits at that time and not just waited for the trial to submit that documentation or evidence to the court. Extenuating circumstances, circumstances that make a crime less reprehensible than it would otherwise be. So, for example, the theft of a loaf of bread to feed a starving child. Extradition, the delivery to one state of a person accused or convicted of an offense committed within the jurisdiction by another state in which that person was apprehended. So the Constitution specifically, the U.S. Constitution specifically talks about this. And if one state realizes, if they've been notified, let's say Florida was notified by Georgia that Florida has in its jurisdiction, within its boundaries, they have John Smith, who absconded from a criminal prosecution in Georgia. If Georgia says to Florida, hey, we want him back, then Florida has to turn him over to the state of Georgia so Georgia can continue with the legal process against him. And so that would be done via the process of extradition.